Before I start, my lords and my ladies, I would like to thank you for having me over for the second time. This is my second opportunity and privilege to address all of you. The topic today is little, what should I say, it's as old as law can be, and at the same time, so far as the applicability of this law to the state of Sikkim is concerned, I am given to understand that there are some issues which need to be addressed, because so far as the rest of India is concerned, the law of partition and the law of succession both are archaic laws in the sense that they are older than the independence of the country. But so far as succession and partition is concerned, they are synced with each other in such a manner that one holds the hand of the other. To put it in right perspective is, I need to have property to have it partitioned. So basically, the way this session has been divided, I think succession should come first. Once I have the property, then we discuss how we divide it. But anyway, we can discuss both of them together. Now, so far as law of succession is concerned, it's basically depending on inheritance or right of the legal heirs to enjoy the property which their predecessors have left behind. Now we all know, I don't need to discuss these basic principles, that succession can be by way of inheritance and can also be by way of testamentary disposition. Now, so far as inheritance is concerned, prior to the 1956 Act coming into force, so far as Hindus are concerned, it was an uncodified law which had developed over the years by way of customs that was prevailing in different tribes, different areas, different sects, different societies. And there were a lot of differences amongst these various customs and societies. So the legislatures felt that there was a need to codify the law. And hence the Hindu Marriage Act, the Hindu Succession Act, all these things came in the year 1955-56. So far as Succession Act is concerned, all over India, Hindu Succession Act is the governing. But I was talking to sir, he was telling me that there is some dichotomy as to whether the Hindu Succession Act squarely applies in the state of Sikkim or not. So I was actually trying to learn from him that it's not that succession is a question which troubles the court every day. If it is amicable, they don't come to court, but if it is not amicable, then people do come to court. Then what is the law that you apply? I am told that there is an act, and I have also seen that there is an act called Sikkim Succession Act 2008, but that has not been given effect to. There is no notification gazetting that act. But I have gone through the act, and it appears to me that it is basically a replica of the principles under the Hindu Succession Act. So far as the intestate succession is concerned, they have bodily lifted the provisions of the section 6 to 9 of the Hindu Succession Act into that. And so far as testamentary succession is concerned, they have taken the principles of Indian Succession Act so far as testamentary succession is concerned. But since they do not squarely apply, but the principles of law are being applied by those courts, so we proceed on the basis that if the principles are to apply, then how far it can be done without the mandate of the statute. That's a question which is bothering sir, and when I was posed with the question, I also had the same question. Because to me, my understanding is, succession cannot be made dependent on equity. It's not a judge's discretion as to what I will succeed. If I am governed by the Mitakshara law, I get a right of succession on birth if I am a son after 2005, and if I was alive when the succession opened, I get a birth even if I am a daughter. That's the 2005 amendment. So that right which I am succeeding is a statutory right. The court cannot say that no, you don't have that right. Now the question is, if that statute does not apply, then how do I go about deciding who succeeds and what does he succeed? Now, while delving on this topic, I think the proper approach should be is follow the general principles. The general principles flow down from the stage when the law was uncodified, and barring Hindu woman's right to property act, because the 56 Act was brought into force only for the purpose of consolidating the rights of women in our country. And that is where we have to follow that, because that is something even equity will not allow you to hold, because the well-known principle is equity always follows the law. So if equity follows the law, we have to acknowledge the principle that women also have a right vis-a-vis the son as on the date of they being in existence when the succession opened. By succession opening, I mean the person from whom we are succeeding, the day he dies. If I am alive, that is what the Supreme Court has interpreted lately, that it's a retroactive right. It's not retrospective, because when this 2005 amendment came, there were a lot of issues whether it is retrospective or not, whether the rights which have already been settled, whether they get reopened, whether it's prospective, that henceforth the daughters will have a right. And ultimately in 2020, considering all the aspects, the Supreme Court has held that no, it is neither retrospective nor prospective, it's retroactive. I shall give the references. By retroactive they mean that under that section, amended section of section 6, that if the son or daughter is alive as on the date the succession opens, then that gives her a right. Even if she was, even if at that point of time the 2005 Act was not there. But that is only one aspect of the matter, so far as rights are concerned. The other aspect of the matter is what happens when we are deciding the rights of Kopasanas in Mitakshara family as regards the self-acquired properties, and what are the modes and manner of dividing it. Now, if we can have the Hindu Succession Act once, I am sure all of you have seen it day in, day out, and what I am going to say is nothing new. But if you have the first line of Hindu Succession Act, I have a copy now. So, this was introduced in 1956 If you see the first, an act to amend and codify the law relating to intestate succession among Hindus. Now, what was being codified was what we generally call the uncodified law, which is to govern by customs. Now, this Succession Act very clearly says that it will only govern the rights as respect of joint Hindu family governed by Mitakshara law. If you now come to section 4 of that, you will find save as otherwise expressly provided in this act. The reason why I am placing this is where I feel the problem lies. Save as otherwise expressly provided in this act, any text, rule of interpretation of Hindu law, or in custom or usage as part of that law in force, immediately before the commencement of this act, kindly mark, shall cease to have effect with respect to any matter for which provision is made in this act. And B, any other law in force immediately before the commencement of this act shall cease to apply to Hindus insofar as it is inconsistent with any provision of the act contained therein. So, the problem that I foresee is, so far as Hindus are concerned, there is a statute which says that operation of any custom, usage or any other law will cease to operate. So if it ceases to operate, then are we still having the right to go back and follow the customs and principles that were operating prior to that? In my respective understanding, subject to what all you feel and what we discussed, I think that it is no more available to us. At the same time, the other problem is, so far as the state of Sikkim is concerned, where I am now, right now, discussing, the Hindu Succession Act has not been squarely adapted to be operating in the state of Sikkim. So the best course available to us probably is to follow the principles that has been laid down in the Hindu Succession Act without saying that the Hindu Succession Act applies. And I have some of the judgments that I have seen decided by the courts in Sikkim, they actually do follow this Hindu Succession Act only. Now, so therefore, the first point, the first problem that I think can be only addressed by taking course to this fact that we follow the principles of Hindu Succession Act, and without saying that as per Hindu Succession Act you are entitled to those rights, if you are deciding some right in the state of Sikkim. If it is anywhere else in India, then obviously this is the governing law. Now, you are all aware that there has been a huge amendment so far as rights of women is concerned in 2005. Prior to that, so far as Section 6 is concerned, I think the old Section 6 is also there in each of the books. You will find that the old law only recognized sons born in a Mitakshara family as being eligible for enjoying property which their successor have acquired through inheritance, not in respect of self-acquired properties. Now, that kept the daughters away. So far as widows and mothers are concerned, prior to the Hindu Succession Act coming into force, their rights were protected by the Hindu Women's Right to Property Act. The Hindu Women's Right to Property Act came in 1937. It did not give the widow and the mother and the daughters a right, but it gave them a right of residence in their respective places till such time their husbands were not there, till their life. They had a life interest so far as their husband's property is concerned and not beyond. Now, that was done away by introducing section 8. No, I'm sorry, section 14. Because the amendment took place only to section 6, not to 2014. Sorry. Property of a female Hindu to be her absolute property. This is where the 56 Act first time recognizes the right of women. Any property possessed by a female Hindu, whether acquired before or after the commencement of this Act, shall be held by her as full owner thereof and not as limited owner. So that 37, that right, that temporary right of residence and life interest which they got under the 37 Act, that got crystallized and done away by the 56 Act. So a Hindu woman holding property as on the date of coming into force by virtue of this Act becomes the absolute owner. This has been recognized by the Supreme Court in very many judgments. So I don't need, because this is also as old as that. Now, then the general rules of succession so far as female Hindus are concerned, if you look very carefully, the property, that's section 15. The property of a female Hindu dying intestate shall devolve according to the rules set out in section 16. Firstly, upon the sons and daughters, including children of a predeceased son or a daughter, and the husband. So, the property which is being acquired as on 56, held by her for a temporary under whatever provision, on her demise also devolves upon the husband. Secondly, upon the heirs of the husband. So it doesn't revert back. Previously it used to revert back. Thirdly, upon the mother and the father. So if you are exhausted on your husband's side, then it goes to the father and mother. Fourthly, upon the heirs of the father. Lastly, upon the heirs of the mother. So this change, and of course, notwithstanding anything, any property inherited by a female from her father or mother, shall devolve in the absence of any son or daughter of the deceased, not upon the other heirs referred in subsection 1, in the order specified therein, but upon the heirs of the husband. Any property inherited by a female Hindu, that's subsection 2, any property inherited by a female Hindu from her father or mother shall devolve in the absence of any son or daughter of the deceased, including the children of the predeceased son, not upon the heirs referred to subsection 1 in the order specified therein, but upon the heirs of the father. So, if it has been coming from the father's side, it goes back. Any property inherited from her husband will go upon the heirs of the husband. But having said that, this right was restricted only to the self-acquired property of a female Hindu as of 1956. This does not address the question which I am trying to. The question is, what does the 2005 amendment introduce? It introduces a right in a co-parson which was never existing prior to the 2005 amendment. There were a lot of debates that if my brother can get a share of the father's property, why can't I? Now ultimately, after a lot of debates, the section 6 has been amended. Now if you have that amended section 6, then I can take you to the other provisions. Devolution of interest in co-parsonary property. On and from the commencement of Hindu Succession Act, Amendment Act 2005, in a joint Hindu family governed by Mitakshara law, the daughter of a co-parsoner shall, by birth, this is the right that has been recognized for the first time, become a co-parsoner in her own right, the same manner as a son. So this is the recognition of a female daughter in a co-parsonary. Prior to that, it was the son, the person of concern, and 3 generations thereafter, they get a right by birth. But the daughters now get. Now the question is, since when? Have the same right in the co-parsonary property as she would have had if she been a son, subject to the same liabilities in respect to the wholesale property as that of a son, and any reference to a Hindu Vritakshara co-parsoner shall be deemed to include a reference to the daughter of the co-parsoner. This is very important, and this is where all the disputes arose. Provided that nothing in this subsection shall affect or invalidate any disposition or alienation, including any partition or testamentary disposition of property which had taken place before the 20th day of December 2004. So, one view was that if the person from whom we are acquiring has passed away prior to 2004, will the daughter get a right? Because you see, the problem arose in 2005. Prior to 2005, the co-parsoners had already got the right. At that time, daughters were not there. So, in many cases, after acquiring a right by the co-parsonary, people have gone on and dealt with the properties. But when in 2005, when the daughter's rights came in, the daughter started challenging that if I was a co-parsoner by birth, then you could not have dealt with those properties because I had a right which you had not recognized. That was the dispute that came up. And in all these cases, initially the Supreme Court held, the first view of Supreme Court well before of Justice Sotomoto Sinai view, that it has to be decided as on the date of the opening of succession. The day this man dies, as on that date, it has to be decided whether the daughter had a right or not. Because he felt that if the daughter's rights were recognized in a retrospective manner, it would create a lot of chaos and pandemonium. Because rights which have already been settled would have to be unsettled. Third-party rights have been created, partitions have taken place, alienations have taken place. So, it was not the intention of the legislation to reopen. The other view was of the Supreme Court was that no, it is obviously prospective. Because it was not the intention by referring to this that it shall not invalidate any disposition, alienation, any partition. The purpose of the legislation was to say that no, this will only take effect prospectively, henceforth. It will not have any retrospective effect. But considering all these decisions, this is where the Supreme Court has now, as of now, has decided any property, if I may go a little further, subsection 2 of section 6, any property to which a female Hindu becomes entitled to by virtue of subsection 1 shall be held to by her with the incidence of co-parsonary ownership and shall be regarded notwithstanding anything contained in this act or any other law for the time as property capable of being disposed of by her testamentary disposition. Then, subsection 3 is the important section in all this. Where Hindu dies after commencement of the Hindu Succession Act 2005, his interest in the property of a joint Hindu family governed by Vritakshara law shall devolve by testamentary or intestate succession as the case may be under this act and not by survivorship, and the co-parsonary shall be deemed to have been divided as if a partition had taken place. So the concept of notional partition is being introduced. Then a daughter is allotted the same share as is allotted to a son, and this is where the important line is the share of a predeceased son or a predeceased daughter as they would have had they been alive at the time of partition shall be allotted to the surviving child of such predeceased son or of such predeceased daughter, and the share of a predeceased child and daughter, son or predeceased daughter, which child would have had one, he or she shall alive at the time of partition shall be allotted to the child or predeceased child of the deceased or a predeceased daughter as the case may be. Now the explanations for the time being are not very relevant. If I may ask, if anybody could share this judgment. Kindly share 2020 volume 9 SCC page 1. I am sure all of you are aware of this judgment, but since we are discussing the latest trends, this judgment decides everything. No, not this. 2020 volume 9 SCC page 1. No, this is table knowledge. Just where is he operating? Oh, you are operating from there. Could you go back to the main? No, this is the 2009 judgment, the 2020 judgment. No. No. Can I pass it on to you? This is Vinita Sharma versus Rakesh Sharma. This one. just in the meantime, if anybody has any questions, they may jot it down for the time being so that I can try and address to the best of my ability. If anybody has any queries regarding the that is what I am trying to. You see, retroactive is basically, before if I go through the words of the judgment, retroactive means that my right gets activated retrospectively. For example, suppose I am governed by Dayabhaga law, so if I had been governed by Vitakshara law, and I was a daughter in the family, and the constitution and the legislatures recognized my right in 2005, after 2005. But my father died in 2004 or 2002. So the question arose that if I am treated from 2005 to be having the same rights as that of a son, so you, the son, you acquired a right by birth in your father's estate when you were born. So if I am now treated to be at par with you, I also acquired a right by birth, although it was recognized subsequently. But when I was born, if I am at par with you, then I was also born when my father was alive. So if I was a co-parsoner from that day under the 2005 amendment, so I also acquired a right. Now that right got activated in 2005. So that's why it's called retroactive. So I became a co-parsoner along with you, having the same rights as on the date of my birth. The other way of putting it, whether I was alive as on the time when my father passed away. Because that is when the succession draws a line. If I was there, then I was alive, I had taken a birth prior to my father. So I become a co-parsoner. That is what the Supreme Court has said, that it is neither retrospective nor prospective. The law recognizes a retroactive right. And this has again opened up a can of worms, because now the daughters have realized that the brothers and the family have dealt with their rights. Now they are coming to court and seeking rights. That's the reason why the second part of the section says that if it is settled already by partition or alienation or by an order of court, then you don't get a right to reopen it. But before I come to that, I just need to show this, because this is the latest judgment which I could lay my hands on Succession Act, subject to, but as I understand, this is being followed as of now. If it is you are unable to do it, I read it out, don't worry. Noted? Yes. Is it synced with you? Oh, that's why I can control it from here. If I may just start, I just give you the breakup because it's a very long judgment. I just give you the breakup. The interesting would be to take care of the arguments that were made, because these are the issues which we face in courts every day. So therefore these arguments were taken into consideration by the court. If you could please bring us to, yes, top of when the judgment starts at page 21. Yes, if you could scroll down a little bit where the judgment starts. I think you are reading the judgment of Justice Ravindra. This is the judgment of Justice Arun Mishra. Yes, this one. Yes. Yes. You see, this question that was decided before the court was the question concerning the interpretation of Section 6 of the Hindu Succession Act 1956 as amended by the Hindu Succession Amendment Act 2005 has been referred to a larger bench in view of the conflicting verdicts. These are the two conflicting verdicts which I was referring to division bench judgments of this court in Prakash Fulvati and Dhanamba versus Amar. In other concerned matters, the question involved is similar. As such, they have also been referred to for hearing along. In so and so, SLP court held that Section 6 as amended by the 2005 Act is deemed to be there since 17 June 1956, when the 1956 Act came into force. The amended provisions are given retrospective effect. This was one view. And all these views were of Supreme Court. Pending proceedings were to be decided in the light of the amended provisions. Inequality has been removed. The High Court held that the oral partition and unregistered partition deeds were excluded from the definition of partition used in such and such. Then in another SLP the question raised is about the retrospectivity of Section 6 as substituted by 2005 Amended Act. And in case the father, who was a co-parsoner in the Hindu family, was not alive when the 2005 Act came into force, whether the daughter would be a co-parsoner of the joint Hindu family property. This was the second view. Then the other view is the question raised is whether the final decree that has been passed in a suit for partition, whether the redistribution of the shares can be claimed by daughters as amended under Section 6 as substituted. This is because of the principle that we have in partition suit is that till such time a final decree is passed, the shares can be allotted any time and re-allotted thereafter. So on that principle, when a Section 6 applies and a partition suit could be reopened. Now the other view is the question raised in paragraph is whether Section 6 is substituted is prospective as the father died in 94 and thus no benefit could have been drawn by the daughters. So these are the questions which fell for consideration. Now kindly if you come to paragraph 8, the Supreme Court in this judgment had held that Section 6 is not retrospective in operation, and it applies when both co-parsoner and his daughter were alive on the date of commencement of the Act of 2005. Kindly mark this. Both co-parsoner and his daughter were to be alive on the date of commencement of the 2005 Act. So that was one view. This court further opined that the provision contained in the explanation to 6.5 provides for the requirement of partition for substituted subsection 6 is to be registered on or by a decree of court can have no application to a statutory notional partition or the opening of succession as provided in the amended section 6. The notional statutory partition is deemed to have taken place to ascertain the share of the deceased co-parsoner, which is not governed either under the provision to 6.1 or section 6 subsection 5, including its explanation. The registration requirement is inapplicable to partition of property by operation of law, which has to be given full effect. So this was the view. Then the arguments are there. Then if you could scroll down, the entire law of the development of the law of succession has been discussed from paragraph 18, which I am not holding you on, because this is something, if you are interested, because this will take a lot of time. Then the co-parsonary and joint Hindu family concept is decided, formation of co-parsonary is decided. Then what I am trying to address is the question of the effect of the amendment. If you could take us to page 50. Paragraph 53, just after the statement and objects. Section 6 deals with devolution of interest in co-parsonary property of a joint Hindu governed by Mitakshara law. The originally enacted provision of Section 6 excluded the rule of succession concerning Mitakshara co-parsonary property. It is provided that the interest of a co-parsoner male Hindu who died after the commencement of the 56th Act shall be governed by survivorship upon the surviving members of the co-parsonary. The exception was provided that if the deceased had left during surviving a female relative specified in class 1 of the schedule or a male relative specified in class who claims through such female relative, the interest of such co-parsoner shall devolve by testamentary succession or intestate succession, as the case may be, in order to ascertain the share of the deceased co-parsoner. The partition has to be deemed before his death. Then explanation to detail is separate. So, paragraph 55 is what the base of what is the reason why this amendment concerning gender discrimination to daughter who always remained a loving daughter. This passage was quoted. Then the schedule was there. If you want to go through it, you can go through it. Let me come to the conclusion straight away, because this will take a lot of time. Kindly come to paragraph 137. This is the law which is currently operating. Resultantly, we under the references as under. The provisions contained in substituted subsection 6 of the Succession Act confer status of a co-parsoner on a daughter born before or after the amendment in the same manner as a son, with same rights and liabilities. The rights can be claimed by a daughter born earlier with effect from 9/9/2005, which savings has provided in 6.1 as to the disposition, alienation, partition or testamentary disposition which had taken place prior to the 20th of December 2004. So, the right is being recognized here. The right can be claimed by a daughter born earlier with effect from 9/9. So, my right gets activated on 9th of September 2005. But it will not upset the dispositions, alienations, partition or testamentary disposition which had taken place prior to that date. So if things have been put at quietus before that date, I do not get a right to unsettle it. Then, since the right in the co-parcenary is by birth, it is not necessary that the father co-parcener should be living as on 9th of September 2005. This is very important. So, the statutory fiction, then the next, the statutory fiction of partition created by the proviso to section 6 of a Hindu Succession Act 1956 as originally enacted did not bring about actual partition or disruption of co-parcenary. So, the partition which the notional concept of notional partition which was there in 2006, the Supreme Court is now saying as originally enacted did not bring about actual partition or disruption of the co-parcenary because it was only notional. The fiction was only for the purpose of ascertaining the share of the deceased co-parcener when he was survived by a female heir of class 1 as specified in schedule to the 1956 Act or a male relative of such female. The provisions of substituted section 6 are required to be given full effect, notwithstanding that a preliminary decree has been passed. The daughters are to be given share in co-parcenary equal to that of a son in pending proceedings for final decree or in appeal. This is the first time where the Supreme Court says that this concept of notional partition which is there in the unamended section 6 is not the actual partition which is there now in the amended section 6. By notional partition, I am sure all of you are aware that when we decide prior to this amendment coming into force, when we used to decide as to who are the co-parceners and what share they had in the co-parcenary property, then the principle was to apply the principles of partition, though not actual, notional, to see who is acquiring a right, because co-parceners hold the property jointly. So if I had a flips of a right, then I become a co-parcener if I was a son or a male member. So that concept of notional partition at that point of time did not take into consideration the daughter's rights. So now the Supreme Court is saying that no, if that notional partition concept was not actual partition, then if a daughter had acquired a right then by birth under the Amendment Act, you have to recognize that right even in pending cases. Suppose a preliminary decree is passed, even a final decree is passed. Supreme Court is saying that even a final decree has been passed in a partition suit and an appeal is pending. The Court of Appeal has to recognize that right of the daughter even then, although originally she did not have a right. There are many partition cases which lie in between the 2005 coming into force, amendment coming into force and subsequent date. So the courts have been directed to take note of daughters' rights unless they come under any of the exceptions in 2006, which I will come later. In view of the rigorous provisions In view of the rigor of provisions of explanation to subsection 6, subsection 5 of the 56 Act, a plea of oral partition cannot be accepted as statutorily recognized mode of partition. So, if you are to deprive a daughter, you will have to have a proper registered deed of partition. The concept of oral partition is no more there. So, previously we used to say that there is a family settlement amongst us which has never been registered because we both understood and agreed that this would be the manner in which we would enjoy our property. Now, in such a scenario, if a daughter has acquired a right, you cannot put up that family settlement and say, or an unregistered deed of partition and say that look, there is already a. Supreme Court is saying that it has to be an actual document having a legal enforceable basis. So, in view of, so if I may just read 137.5, in view of the rigor of provisions of explanation to 6.5 of the 56th Act, a plea of oral partition cannot be accepted as statutorily recognized mode of partition, affected by a deed of partition, duly registered under the provisions of the Registration Act 1908, or affected by a decree of court. However, in exceptional cases, where plea of partition is supported by public documents, and partition is finally evinced in the same manner as if it had been effected by a decree of court, it may be accepted. This is where the discretion of the court has been kept open. Because there could be cases of partition that following a oral partition, the parties have not only divided the property, enjoying them, and some of them may have also alienated it on the basis of that oral partition. Now that alienation brings in the rights of third parties. So in those cases, the daughter cannot come and say that no, you will have to reopen it, set back the clock so that I get a right. So this is a place where the court has to exercise discretion. We understand that on this question, suits appeals are pending before different courts and subordinate courts. The matters have already been delayed due to legal imbroglio caused by the conflicting decisions. The daughters cannot be deprived of their right of equality conferred upon them by Section 6. Hence, we request the pending matters be decided as far as possible within 6 months. So, by doing this, the initial two judgments which said it is retrospective or retroactive have been overruled.
Okay, I found this on the web for who is the pending.
Is this also under your control? So, my lords and my ladies, this is the latest development so far as the law of succession in India is concerned. Now, if we proceed with what are the exceptions which the Supreme Court was saying, that you will find in the later portion of that amended Section 6. Now, if I may just trouble you with the exceptions, explanations and the exceptions. The explanation to first explanation to Section 6 as amended is the concept of notional partition which the Supreme Court was referring to. For the purpose of this subsection, the interest of a Hindu mitakshara uparsana shall deem to be the share in the property that would have been allotted to him if a partition of the property had taken place immediately before his death irrespective of whether he was entitled to claim partition or not. That is notional partition. Not actual, but partition by partition by implication of statute. Then, after the commencement of the Hindu Succession Amendment Act, no court shall recognize any right to proceed against a son, grandson or great-grandson for recovery of any debt due to his father, grandfather or great solely on the ground of pious obligation under the Hindu laws of such son, grandson or great-grandson to discharge any such debt, provided that in case of any debt contracted from the commencement of the Hindu Amendment Act, nothing in this subsection shall affect the right of a creditor to proceed against the son, grandson, as the case may be not relevant. This is important. Any alienation made in respect of or in satisfaction of any debt, and any such right or alienation shall be enforceable under the pious obligation in the same manner and the same extent as would have been enforceable as the Hindu Succession Amendment Act had not been enacted. So this is where the amendment does not extend. And 5 is what the Supreme Court is now saying, subsection 5. Nothing contained in this section shall apply to a partition. By partition, the meaning not oral partition, a partition which is recognized in law, or a partition which is deed is registered, or a partition which has been acted upon and closed prior to coming into force of this act, which has been effected before 2004. And this explanation for the purpose of this section, partition means any partition made by execution of a deed of partition duly registered under the Registration Act, or partition effected by a decree of court. These are the two forms, and the third form is where the court has said that if the court is satisfied that no, this was a genuine partition and it was not an act to defeat the right of the daughter. So this is so far as the daughter's rights are concerned. The female's rights were already recognized since 1956. There has been no amendment to sections 14 and 15. And so far as section 8 is concerned, this is the right of the legal heirs governed by Mitakshara law to succession of self-acquired properties. Now, I am sure you must have noticed that the difference between section 6 and 8 is section 6 deals with rights under a joint Hindu family, and section 8 deals with property of a male Hindu. So one is the property which he gets under Mitakshara law, and this is the property which is his self-acquired property. If it is self-acquired property, the law from 56 is still the same. Class 1, class 2, class 3, class 1 excludes class 2 excludes class 3. People in class 1 take equally, people in class 2 take by past trips or per capita, and that law remains the same. And of course, nothing has been touched so far as testamentary succession is concerned. That is section 30, that has remained as it is. So, this is so far as if you have any questions on this is so far as the first topic, law of succession and inheritance and the latest developments on it. Partition I will come later because we must know what we have before we divide. So if you have any questions, I'll try and answer them to the best. So coming back to where I started, is that since this act is not recognized, as I am told, in the state of Sikkim, now how do we go about it? So we will have to follow a process where we don't offend section 4. as well as follow section 6 to the extent equitably possible. Like, we cannot go back to since section 4 does not apply, we cannot go back to a position and put the parties in a position where they are bound by religious and customs which have been expressly done away by the statute. At the same time, today we cannot stand here and say that women do not have a right in co-parson. Now, how far will the court recognize a right and how far will a judge allow a female co-parsoner to come and reopen is the guiding principles and there in section 6, I believe. The sum and substance of it is that if it has been acted upon and not with the intent of defeating the rights of a woman, but actually, then courts will recognize it. But if it so appears that these transactions have taken place only to keep the daughters out of the right of succession, then courts will ignore them and recognize the rights. This is the sum and substance of section 6. So, if you don't have any questions, then do I proceed with partition?
So why don't you have second court?
No, sorry. Now there are 2 or 3 more other topics which I would like to first know from you before I proceed to what is the law that is followed here so far as partition is concerned? Do we follow the Partition Act? It has only 4 sections. Then, if I go before any court or district court in Sikkim and I seek partition, what do we do? Because you see, the reason why I ask all of you this question is, if I go before a court and say that I want to seek partition, then the first question arises is your locus. By locus I mean, do you have a pre-existing right in the property to be divided? Now, the reason why I ask you this is my pre-existing right in the property or my right in the property can come by way of 2 ways. Either by intestate succession or testamentary succession. If it is testamentary, then the Indian Succession Act will take care of it. If I have a probate, then that probate will give me a right to claim partition. But if it is intestate succession and the Succession Act does not apply, then the bigger question is, the judge facing this situation, will he first have to decide on equity whether he has a right and then give partition? Or will he have to just say that, well, you somewhere get a decree or ascertain your right? In other words, what I am trying to say, that in a court who is deciding partition, is the decision of your right in the property inbuilt in that decision? Do you have to first ascertain? So if it is inbuilt, so today if a daughter belonging to a co-parsonary Hindu family residing in Sikkim applies for partition of his property vis-a-vis his brother on the principles of section 6, he doesn't say something. He said, both my brother and myself are not happy enjoying the property jointly, divide it. Now, as you rightly said, that the decision of whether you have a right is inbuilt in that decree itself, which is the preliminary decree form of it. But can you in that suit, the question is, can you in that suit say that by virtue of Hindu Succession Act not applying to Sikkim, you don't have a right in law? Well, obviously this seems no, but the thing is, the question that is bothering me is, if it is a statutory right, the problem, if it is a right which the statute gives me, then all statutes have an application clause. That this statute will apply to this area, to this group of people, to this subject. We are faced with the situation that the statute has not been adopted in the manner it should have been done under Article 371. So today, if a daughter comes and says, I want a partition from my son, from my brother, will the courts in Sikkim or the judges who are faced with this issue get a right to say that, look, although the statute does not apply to us strictly, but a right has been recognized of a daughter, and by virtue of you being a daughter in the family, you are entitled to. Can we say that today? Because that's a statutory right, that's not an equitable right. The bigger problem would be if there are 3 daughters and 2 sons in that family, and any one of the daughters come and say that, give me my share. It is well settled, I don't need to reiterate that in that case, the court has to divide everybody's share. So in a suit for partition, it's one effort to divide the share amongst all the co-sharers. There cannot be a partition that only one person takes his share out and the rest remain joint. If it has to be partitioned, it has to be partitioned among all. If possible in meets and bounds, or if not possible, the other way of transfer of OLT money. But to take that call, you will have to pass through that line of notional partition. You will have to decide that whether in that family which had 3 sons, 3 daughters and 2 sons, as on the date the father died, whether the daughters had acquired a right. So this is the question that is bothering me, that this is recognition of a right which is governed by a statute. Can it be recognized in equity and good conscience? Because if it is based on equity, as I was talking to the director, he says that we try and follow the principles of equity and good conscience because there cannot be a problem which law doesn't have an answer to. So if it is equity, then equity is somewhere a discretion of the court. Equity is not statute bound. So whatever the statute does not provide, equity steps in. But if the statute provides something, then equity doesn't have a right because equity follows the law. Equity doesn't. In that situation, I think the safest way of detailing is to insist that in the suit for partition, although it's inbuilt, we declare the rights of the parties in the preliminary decree in accordance with section 6 if Mitakshara law is applicable. Otherwise, we can't say, at least I don't see any court say that equitably each one of them is equal to entitled to an equal share. Because that is not the case so far as section 8 or class 1 to 3 is concerned. It depends on which class you belong. Your share will depend on which class you belong. So this declaration or operation of section 6 and section 8 is inbuilt in that preliminary decree. And I think we will have to go ahead and say that as per the latest amendment and as per the principles of law that is applied all over India, the daughters do have a right. This law of partition is, as I told you, you can see in the screen the law of partition is of 1893. If you have any queries, we can discuss.
In the constitution itself, the right to equality, that maybe we can draw something from.
So
Non-discrimination based on sex.
In the constitution there is law of equality, Article 14 you are talking of. Yes,
Non-discrimination based on sex of a person. So
that is where I was exactly trying to say. We are not discriminating. We are treating them as same. But the quantum of share is not equal. If you apply the Hindu Succession Act, if you are a class 2 heir and a class 1 heir, if there is a class 1 then class 2 does not apply. If you are class 2, all of you are class 2, then the quantum of your share will differ. There may be persons who are getting shares through, so 1/4 becomes half, half becomes 1/3, 1/3 becomes quarter. So I am not saying that we are not treating the daughters and sons equally. The plaintiffs and the defendants are being treated equally. But the question is that my right to get more because I am class 1, depriving class 2 is a statutory right. Suppose I am a son and there is a class 2 heir. The law says that if there is a class 1 heir, the rest gets excluded. If class 1 does not apply at all, then the class 2 heir will, by virtue of Article 14, can say that treat me same as that of a son. So what, I am a class 2 heir? This law does not apply here. And I don't think equity can solve this problem. Because if you say treat all of them equally, then you are putting all the class 1, class 2, agnates, cognates, all of them in one group and say distribute it equally. But that is, the statute does not recognize, the law does not give. If
so if you see the customs, normally property is inherited by the wife or the son. It does not go to class 2 heirs. In any custom you see, property is normally given, passed over to the son.
Sir, when you say that, you please read section 4, that is what I was trying to understand from you. That section 4 of the Hindu Succession Act from 56 does have a bit of this. That is why I started by reading section 4. That today we are in such a situation, we can't go by the Succession Act, nor can we go back by the custom because that has been expressly prohibited. That prohibition is there that you cannot follow. Of course, customs are followed. In tribals, I believe they have their own customs. The communities, they have other customs. The Muslim people have their own way of their own personal laws which govern them. But personal laws are saved by the Constitution. So, in the absence of any personal law, customs, I don't think a court of law today in this state can say that if this is the custom. Yes, what you are saying is if the widow is there and the son is there, they get it equally. Now what happens is that in the same scenario, the widow is there, the son is there, and there are 2 daughters. And one of the daughters today come and say that by virtue of this decision of the Supreme Court, I was also alive as on that date my father passed away, so I also get a right. This is the problem which this amendment has brought about. So, now what does the court do? The court has to see, well, so far as the daughter and so far as the widow and son is concerned, they may not have done anything. They are continuing their life as if they are both jointly owning the property. Now when the daughter comes in and says, give me my share, I want a partition, then the problem arises. Suppose it's a house. The mother and the widow with the mother and the son is living together. They say they continue their life as it is in the absence of the father. Now when the daughter comes in and says, give me my share, as of now, if they are governed by Mitaksharas, the daughter has a share. So your share gets minimized by operation of law in a retroactive manner. So, if it is not already concluded by a partition or by a registered deed recognizing their rights, then you have to acknowledge that. There is no running away from it, even if the law does not apply. If I may ask this question, None of these succession matters after the amendment of 2005 have gone up to the apex court from here. Nobody has challenged it. So because there it will fall for a decision whether which law will apply. I also could not lay my hands on any Supreme Court decision as regards the state of Sikkim is concerned. But I'll bring this to the notice of the Chief Justice. That I do. I need to talk to him about this. So far as partition is concerned, as I told you that Partition Act of 1893 is even older than our independence. But do you follow the law, Partition Act? Does the Partition Act apply over here or it doesn't? This Partition Act which is on the screen, does it apply?
Not sure whether it's enforced or not.
Sorry?
Not sure whether it's enforced or not.
Okay. Well, even if it doesn't apply, the law of partition is more or less governed by judgments and statute. Statute more or less has no claim. And if I am discussing partition, let me just give you the topics. If you want to join any additional topic, you can join. But these are generally the questions which apply in the suit for partition. The simplest way to define partition is division of a pre-existing right. That is how the Supreme Court has done it, and I still believe that this is the simplest way of doing it. If you have a pre-existing right, then the concept of partition applies. Now, concept of partition presupposes joint ownership. Because if there is no joint ownership, there is no concept of any partition. Because by partition, what you are trying to do, you are trying to bifurcate and divide that joint ownership and the right of enjoying that property. So, a joint ownership is intrinsically connected with Section 6 of the Hindu Succession Act. Similarly, people inheriting properties or the legal heirs inheriting properties of their father under Section 8, they do it jointly. And of course, if there is testamentary disposition, the parties who get it, unless the will otherwise makes a partition within it, you inherit the rights jointly. These are the three rules. Now, the concept of owning a joint property is very akin to rights of parties of tenants in common under the English law. The nature of joint ownership means that everybody has an equal right over everything. When we were in college, the easiest way of putting it was, if it is a house and there are 3 joint owners, everybody has 1/3 share on each brick of the house. So joint ownership is every right enjoyed by every owner of the property. So the persons can be members of the family. The persons may become joint co-owners or co-sharers by virtue of inheritance. They can also become joint co-owners by equally contributing and acquiring a property. If 5 friends of mine, we go and purchase a property today, putting in money, then we also become joint owners of that property. So the concept of jointness of property is everybody's rights, equal rights being recognized in that property. That does not necessarily mean that everybody's contribution or everybody's right in the property is also the same. Then this is the first. Suppose I give an example, which is the most commonest problem which we face in all suits for partition, is that more often than not we find if there are three brothers who jointly own a property, each one of them may not be financially well off. One may be financially strong, the other may be financially weak. One may be in a position to contribute more, the one may be in a position to contribute less. Now these three brothers, they stay in a house, which is the joint property. They might have inherited it. The problem occurs is when the brother who is financially sound and well off, he does the majority of the maintenance of the property. He does the majority of the improvements in the property. And he does it with the knowledge of the other two co-sharers who are beneficiaries of this benefit but do not contribute equally. In that situation, the problem that arises is if a partition is sought of for property of this nature, the person who had all these years prior to partition had looked up to the property feels that this property I am entitled to more because I have maintained the property. And the other two brothers have neither paid nor done anything so far as maintenance of the property is concerned, and therefore I should get more equity. Now, the law previously was that if you have made investments in the property with the consent of the other two co-owners, and they have consented to either expressly or have allowed you to make, which is not simply maintenance but something more, then in equity you may be entitled to be compensated for that additional cost in terms of money, but not in sharing the property. But there is a subtle difference between whether it was essential maintenance of the property or it was, suppose if I have a house and I lay the floor with the best Italian marble, that was not maintenance per se. These are questions which come up. It could have been done by any ordinary marble, but since I am influential, I have done it by putting in the best, most expensive marble. At the time of partition, when the commissioner of partition goes to partition the property, he is to take note of this fact. If any one of them complains that I am entitled to something more because I have done this, or I am entitled to this portion of the house because I have made this. Under the law of partition, even if you have done anything on the joint property, you have done it at your own risk. You don't get any extra right for that. But yes, if I have done it with the knowledge and consent of the other co-owners, at the time of balancing my rights, the commissioner has to take note of this and might ask the other co-owners, well, look, this extra cost which has gone into a joint property, you had also enjoyed the benefits of this. So you will have to compensate this man because today he has to give it up because of the partition. This is one of the concepts which very often we find a problem in courts, not with the courts but with the commissioner. The other is contributions. That is another thing which courts, while dealing with partition and prior to preliminary decree, more often face this problem. Is suppose three of our brothers or two or three co-owners, they acquire a property. They acquire it jointly from a third party. And the deed says that A, B, C has purchased the property jointly from D. And that is the only document the parties have to prove their joint ownership. Now, when it comes for partition, it appears that at the time of acquiring the property, B has actually not paid anything. B's contribution is not there. It is only A and C who has paid, but the document, which is the deed, that recognizes B as an equal co-owner to the property. Now the question is, in this situation, the registered document ensures the title has passed on equally to B. But B is unable to show that he has contributed anything to the acquiring of the property. Then the question that arises is the B entitled to a share in the property? There the courts have unanimously held that a co-owner does not have a charge over the property of another co-owner. The fact that A has not paid or B's share has been paid by A and C does not entitle them to say that I have a charge over the property of B. Because a co-owner cannot have a charge over the rights of another co-owner in the capacity as co-owners. Then what's the way out? The way out is during the passing of the preliminary decree or thereafter, B would be called upon to contribute his share in the property or compensate them by giving up that equivalent amount of right in the property. But so far as courts are concerned, courts cannot compel B to give up an equivalent right. Court can compel B only to contribute, which would be a order which is executable. If it is executable, then the share of B's property can be executed and attached, and whatever the law of execution is. But court cannot compel B to give up his right as a co-owner in a suit for partition. This is another aspect which we more often than not face in suits for partition. Then of course, in old cities where I belong and where there are very old houses, more often than not the question is improvements and repairs made by one, the one I was just saying, improvements and repairs made by one co-owner who claims additional right over that. The other problem which more often than not surfaces in the suit for partition is, suppose there are 3 brothers or 4 brothers and one of them reside abroad and 3 reside in that residential common house. And by virtue of this brother residing abroad, he doesn't have possession of any portion of the house. He has a right, but he has no possession. It's being enjoyed by the rest of the 3. If he wants to acquire a right in common, what will the courts do? If he wants to acquire a right in the property in isolation or separation from the other brothers, then he can file a suit for partition. That's well established. He files a suit for partition, he gets a share allotted or whatever, but he wants to come back and stay in the house, and he says, give me a portion of my undivided right in that. I have a right. But since by virtue of not being in the house, I am not in possession of any portion of the house. Now faced with such a situation, even in a suit for partition or otherwise, in a suit, it's a suit for declaration that I am an undivided and I claim possession. The question that comes up is, can the court, at the instance of one co-sharer, ask the other co-sharer to vacate? Because the person who is complaining is the co-sharer. The person who is sought to be evicted or removed from a portion of his possession is also a co-sharer. Both of them have equal rights. And the fact that this person is occupying this entire, the other three brothers are occupying the occupied house, the entire house, is by virtue of their rights in law. They are not illegally encroaching or approaching on anybody else's property. So, more often than not, courts have refused to give injunction or pass orders directing a co-sharer to vacate and hand over possession. So the ultimate solution to this problem is to seek for partition. Because the law is possession of one co-sharer is for himself and on behalf of all. And that is the reason why the law of limitation does not apply to suits for partition. Because the person who is holding the property as a co-sharer is holding the property and enjoying the property for himself and also on behalf of the other co-sharers. So, on that principle, courts have refused at the instance of a co-sharer to dispossess another co-sharer from the property. And the only recourse left is to sue for partition and separation of my share. Even during the continuance of this suit for partition, courts have also refused injunction and have said that the status should not be altered just because the suit for partition. Now, these things take various shapes and forms. If you go back to the 1900 judgments, you will find more often than not that bighas of land were being cultivated by one brother and one brother is working somewhere else. Now all of a sudden when the crop is on the field and somebody comes and asks for partition, which he is entitled to, then what happens to the crop? The crop does not belong to the brother, but the crop is embedded in the earth which belongs to the brother. So those questions arose, that is the brother entitled to the crop along with the land? There the courts have said no. You are not. He was holding for you as well as on his behalf. So if the crop on the land belongs to the person who has. So that concept has developed over nowadays. It has now come to houses. That if you are occupying the whole house and I am out of the house and I want to go in, the only way is by way of partition. And courts have not recognized an injunction. So that is no injunction against a co-owner. The other interesting thing is, if a co-owner develops or constructs on the land of another co-owner by infringing a portion of it, will the court demolish the construction or will the court allow the co-owner to continue? The obvious answer would be no, demolition, but the law of partition says that no. If you have allowed something, you have acquiesced in that other brother to encroach on your land. And if you have acquiesced to it, and if it is not significant enough, then the court will compensate you, but will not order any order of demolition against the co-owner. So these are some of the basic principles these are the basic problems which occurred. That's the reason I brought it up. If you have any other queries, you can go ahead. Otherwise, we move into the concept of suit for partition and all. Before I proceed, I think there is another aspect of the matter which regarding succession which we need to discuss if you want to. You must be aware that there are two schools of, one is Mitakshara and one is Dayabhaga. But Dayabhaga is only restricted to Bengal, and the principles of Dayabhaga are entirely different from that of Mitakshara. So I don't think any of us here come across cases relating to Dayabhaga, because a man can carry his personal law with him also. So more often than not, if you are residing, if I am from Bengal and if I come and reside over here and I have acquired properties over here, the question may arise that when it comes to partition or succession of my property, whether the Mitakshara law will apply because the property is in a state where the Mitakshara Dayabhaga law does not operate, or while I was migrating from Bengal to Sikkim or any other state, did I carry my personal law with me?
Sir, the person from another state, and we can't acquire the property here. So the example that you are giving wouldn't be applicable.
So this so far, madam, so far as Sikkim is concerned, what happens that if I go from Bombay to Delhi or from Calcutta to Delhi? In Delhi, the Dayabhaga law does not apply. So here, of course, that question will not arise, but the thing is that so far as my ancestral properties are concerned, they would be governed by the law as on the date the acquisition took place, or the inheritance took place. So my properties in Bengal, if I have owners of some properties in West Bengal and some properties in Delhi, then if I want the Dayabhaga law to apply to my properties in Delhi also, then I'll have to show before the court that I had actually carried my personal law along with me, number one. What does it mean by carrying the personal law with me? Meaning thereby that the manner in which the property was managed and handled, we did not bring into or acquire the Mitakshara law that is applied to the place where the property is situated. Meaning thereby, suppose my father had 4 sons, 2 of them staying in Bengal, enjoying the properties in Bengal, 2 of them staying in Delhi and enjoying his properties in Delhi. Suppose this is the situation. Then on the demise of my father, the question will automatically arise as if you are going to seek partition, and if you are seeking partition in Bengal, in a suit filed in Bengal, will that same law apply to the properties in Delhi? The question is yes. Answer is yes. Because it's not the place where the property is situated that governs. Since it's a personal law, it's the law which I carry with me. But if it so transpires that so far as the property in Delhi is concerned, I have treated during my lifetime my 2 sons as co-owners of the property along with me, then I have acquired that law of that country or that law of that state, which is the Mitakshara law. So I was not carrying my personal law with me over here. Because in Dayabhaga, you don't have co-owners amongst class 1 and class 2. It's only one owner who is the Karta of the joint family, and he takes a call after his demise as to how the property would be divided, if it is testamentary. If it is intestate, then it's equally. That's the difference between Dayabhaga. This is something it escaped my notice, but here it does not apply. So we may not discuss that. Now, the topic which is here is nature of property liable for partition with reference to coparcenary. So far, coparcenary property is concerned, there are two rights. One is right under section 6, one is right under section 8. Section 6 applies to if I am a member of a joint Hindu family, which is a co-parsoner, then as on the date when the succession falls, there is no necessity for any succession or succession certificate, because on my birth, the law automatically takes effect. So I acquire a vested right in the co-parsonary property, irrespective of the fact whether it's recognized or not, which now applies both to sons and daughters. So far as my self-acquired properties are concerned, which are not forming part of the joint Hindu Calcutta family, that would be governed by Section 8 if it's a male. If I am a female, it will be governed by Section 14. And the line of succession is there in 8, it's the schedule. And if it is a female, then the line of succession is governed by Section 15 and 16 of the Hindu Succession Act. So that way, so far as co-parsonary property is concerned, which is property belonging to the joint Hindu family, my right gets recognized by way of the concept of notional partition which I was talking of. When it comes to actual physical partition, the court will have to decide which property belongs to the co-parsonary and which property is the self-acquired property. So if a person or a legal heir falls under both of these categories, then he will be acquiring a notional right or a right on actual partition vis-a-vis the co-parsonary, which right he would be sharing with other co-parsoners. And so far as self-acquired property is concerned, that would be a partition within that family. Of if it's a male, if it's my father's property, then Section 8. If it is my mother's property, then Section 14. So that way, this is the way we divide properties in co-parsonary in a suit for partition. Now, partition suit or a suit for partition presupposes, as I said, presupposes the basic notion is division of a pre-existing right in the property. So anybody seeking partition, the first, as a plaintiff, the first right which he has to satisfy the court is that he has an existing right on the property of which he seeks partition, number one. Number two, since it is a pre-existing right in the property, a right which is inherent in me from my birth, there cannot be a question of any limitation for that. Because whatever is my right is the right of other co-owner. That brings us to the third principle, that there can be more than one partition suit in respect of the same property. It's not hit by the principles of res judicata or abuse of the process. Even if a partition suit is dismissed, another co-owner can come and file a second partition suit. He need not restore the first suit, which is against the principles of Order 9 of the Civil Procedure Code. So therefore, you can file as many partition suits as any co-owner can go on filing partition suits. And that's the reason the courts have evolved a theory that if it has to be a partition, it has to be a partition of the partition and determination of rights of all the co-sharers. So all the persons interested must be parties to that suit. No single co-sharer can come and say that give me my share and the rest remain joint. Even if they say so, it is the duty of the court to divide, because until and unless you divide and demarcate the shares, division is different. So far as ascertaining of the shares is concerned, it has to be done vis-a-vis each of the co-sharers of the property. These are settled principles. Now, a partition suit, as we all know, comprises of two stages. One is from the time of institution of the suit till passing of a preliminary decree, and thereafter the working of the preliminary decree and the ultimate final decree. So far as preliminary decree is concerned, the court is not concerned with the fact as to how the property is to be partitioned. That's not the lookout of the court. The court is only concerned with recognizing the rights of the parties vis-a-vis the property in question. Three questions arise. Is it joint? If it is joint, do the plaintiffs and the defendants have a right in the property? And if so, what are the rights? What is the share of rights? And that is all that the court declares in a suit for partition while passing a preliminary decree. Once the preliminary decree is passed and the rights of the parties are recognized, then comes the second aspect of it. A commissioner, because court cannot go and physically visit the property, or a judge cannot go and physically visit the property and partition it, so it appoints a commissioner. A commissioner is under this suit for partition is given all the rights to consult, visit the property and see to it if the property, this is very important, that the property can be enjoyed by all the co-sharers equally. That's the cardinal principle of partition. If it cannot be, if it is destructive, if partition is destructive, then the court on the report of the commissioner will say that it is an impartible property. It's not that every time a partition suit is filed, the suit can be partitioned. The property can be partitioned. So the second stage in this suit for partition is where all the disputes arise, because the person who comes to court and seeks partition acknowledges the fact that I am a co-owner along with the other co-owners. So that aspect is little easier until and unless issues like adoption come in, issues like gifts inter parties come in, issues like family settlement come in. Unless these issues crop up, then declaring the shares of the parties in a preliminary decree is not much of an issue. Problem is dividing the property. The effort of the court always has been to, if a property can be divided, it has to be divided in such a manner that all the co-sharers are placed equally. But more often than not, we find that it is not possible. If one co-sharer gets A portion A of the property and another is given B, then the B says that why will not I take that portion which A is getting and why is he not giving this property? So this is a major issue that crops up in every partition suit, and the resultant effect is when the commissioner files a report, each one of the co-owners come and say that I am challenging the report, I am not happy with it. There comes the second aspect. If the property cannot be partitioned or is impartible, then comes the question of valuation. I am talking of immovable property right now. So the question is, if it cannot be partitioned, then it has to be put on for auction. Because you 3 or 4 or whoever the co-owners are, they are not in a position to enjoy the property jointly. At the same time, the property is not even capable of being divided amongst the co-owners. So the only remedy left to court is to put the property for auction. Once you put the property for auction, whatever price it fetches, it can be divided amongst the 4. And in that auction, a co-owner can also participate and outbid and buy off the rights of others. So that way, the court tries to balance the equities amongst the parties to the extent possible. But as I said, the reason why partition suits get prolonged is nobody is happy with what he gets. Because some may feel that one is happy to retain the property, the other is not happy to retain the property. He will want to exchange. He said, you take my share and give me your share, because both of us are equal. So in those situations, courts have always resorted to paying of OLT money. If I am getting a benefit of a balcony in a portion of the house and my brother in the other portion of the house doesn't have a balcony, then the court will say that you give him some ONT money in lieu of it, so that you provide him that compensation of the extra benefit that you are getting because of this. So that way courts have in a manner have devised the ways of putting the parties in equal position. But as I keep on repeating, because I myself had acted in commission in one or two matters, I have never found that I could make any or all of them happy. None of them are happy. Some say that you are biased, some say you are leaning towards my brother, some say I will go and complain to court, and these things go on, but none of them are happy, and that is the fact of the scene. Now, so far as various modes of partition are concerned, there is nothing much to say except the fact that partition can be by inter-parties, just a minute. Partition can be inter-parties, that is, parties among themselves mutually decide. Now, in inter-party partition, what is very important and significant, and that's the reason why this is the most favorable way of achieving partition, is I have more often than not seen that co-owners, if they are agreeable and if they are amiable to each other, they tend to partition a portion of it and keep portion of the property joint, if they are willing to. If this is not possible and amicable partition is not possible, the only other way is filing a suit, going to court and asking for partition. Now, there are certain things which are not capable of being partitioned. For example, if it is a co-personary property, a self-acquired property is not capable of partition in the partition suit filed for dividing the Mitakshar property. There are some old cases where properties are inherited by virtue of customs, like right to the throne, right to zamindari. These are rights which are not capable of partition because they are inherited by way of customs. These are not open to partition. Places of worship are not capable of partition. There are cases which you will come across that the idol is consecrated inside a house. Each one of us have, some also have Thakur gods inside their house. In all these cases, so far as the consecration of the deity is concerned, the place where the deity is holding is not subject matter of partition. There have been cases where the entire house has been dedicated to a deity, which in Bengal we call Devoto. The property is dedicated to the deity. The deity becomes the owner. Even if the persons have purchased the property, that property is not capable of partition because the property belongs to the deity and you only get the right to enjoy the property. Now, Devottor is something, are you aware of this concept of Devottor in Sikkim? No. Devottor is in parts of eastern India where there were pear-shaped, these people have big houses, lots of land, and very many co-sharers, 7 sons, 8 daughters in the family, and they used to find that the sons or daughters are regularly fighting amongst themselves, and they wanted to preserve the property. Preserve the property beyond the lifetime of the next generation and not defeat the rule of perpetuity at the same time. So what they used to do, they used to dedicate, buy these properties and dedicate this property in favor of the deity. So the deity becomes the owner of the property and you only get a right to do the Seva Puja of the deity. So the persons and their family members who are actually enjoying these properties, they don't acquire a right in the property, they only get a right to enjoy the property. This way, these people used to carry on the right to retain the property because the deity is a perpetual minor. It's the duty of the court to protect the interest of a perpetual minor. So the court becomes the custodian, the property remains undivided, though none of the co-sharers can sell the property, they can only enjoy the property and pass it on to the next generation. That was one of the devices which in parts of eastern India we used to do for the purpose, and we still do it. The property is still. The problem that crops up is that since nobody is the owner of the property, nobody maintains the property because they is not generating any income. So then the question comes that this property becomes dilapidated. And there are provisions where you can apply to the court for selling of a portion of the property and then maintain, but that's a different chapter altogether. So devotional properties and properties belonging to the ideal cannot be partitioned. What cannot be partitioned also is a right of way, easementary rights. That cannot be partitioned even in a suit for partition. Now the other two modes of partition, other than going to court or mutual, is partition by way of will. That is a very well recognized concept in our country. More often than not, any testamentary disposition always provides for partition until and unless the testator feels that I leave it to the next generation. Otherwise it's partition, and this is a recognized mode of partition. If a probate is obtained of that will, then partition can be given effect to in terms of that will. And if there is a dispute thereafter and the matter goes to a civil court for adjudication, the court will have to honor the intentions of the testator and divide the property in the manner as has been indicated in the will. And in that case, the partition may not be equal for both but since it's the desire of the testator and testamentary disposition is permissible in law, then the co-sharers have to accept whatever has come to them. The other way of doing partition is by way of trust. Suppose I am the owner of a huge property and I have 3 or 4 sons and daughters. I want to enjoy the property during my lifetime and I want my sons and daughters to maintain my wife after my demise. I create a trust of which I am the beneficiary first. Thereafter, during the lifetime of my widow, they enjoy the property. And after that, the trust will come to an end and the property would thereafter be divided. So that's the mode of holding control over the property beyond my life and at the same time effecting partition by way of deed of trust. Even trust deeds also have partition schemes feminine to it, in which after the extinction of my life interest, I may devise a method and manner in which the property would be demarcated and distributed amongst them. So that's another way of creating partition. And the last is too well known. We can go to arbitration and also. So these are the various modes and manners in which a partition can be given effect to. Since on this issue, persons entitled to seek partition it goes without saying that you have to be a co-owner or a co-partner to get partition. But there is another group of persons who are entitled to partition, is the concept of en ventre samia, is a child in the womb. A child in the womb, if he is there as of the date the partition takes effect, he is entitled to a share. And he gets it. If he is not happy, he can even file a suit through a guardian once he is in this, once he comes in this world, that he challenges the partition. So that is a very rare scenario, but the law recognizes that right in co-partners also. Now the next topic is not of partition suit, status of third party purchaser and preliminary decree, final decree and mean profits. I don't think I need to address you on partition suits. This is too elementary for all of you. I don't know why this topic is here, but as I told you, partition suits are governed by the Civil Procedure Code. The manner of decree is in order 20, the preliminary decree, final decree, and there is a form of a decree provided in the Civil Procedure Code itself as to how a commissioner is to be appointed, and all that is there. I don't need to go into that. The question is third party purchasers' rights. Third party purchasers' rights to seek partition can only arise if he acquires an undivided interest in the property. The concept of partition is joint ownership. Joint ownership is amongst the members of a family, or maybe otherwise. Now, a third party purchaser, any one of the co-sharers who does not have a distinct right in the property, has a right to sell off his undivided share. That is an undivided, undemarcated share which he passes it on to the third party purchaser. Now, the third party purchaser is not accepted in the joint family. And that's the reason law has given two rights. If it is a residential house, then the moment the third party purchaser seeks separate partition and possession, the co-owners have a right to seek for preemption. The concept is that we don't want you in the joint family, you are a rank outsider. If you are seeking partition, whatever is the amount of your deed value, we are ready to pay you off, but we will acquire your share. So the law of preemption is connected with the law of partition so far as third party is concerned. And this law is recognized in three places. One is under the West Bengal Estate Acquisition Act, which is not necessary for here. It's probably recognized under section 44 of the Transfer of Property Act. As also, do we have a Transfer of Property Act over here? Let me see the what are. Could you scroll down to section 44? No. Let me see whether I'm right or not. Yes. 44. Could you come to 44, please? Scroll up. This is what I was talking about. So if one co-owner, can I have the first half of section 44? Transferred by one co-owner, where one of two or more co-owners of immovable property legally competent in their behalf transfers his share of such property or in interest therein, the transferee acquires as to such share or interest, and so far as is necessary to give effect to the transfer, the transferor's right to joint possession or other common or part enjoyment of the property, and this is where he gets the right to enforce the partition of the same, but subject to the condition of liabilities affecting at the date of transfer the share of the interest. Then where the transferee of a share of a dwelling house belonging to an undivided family is not a member of the family, nothing in this section shall be deemed to entitle him to joint possession or other common or part enjoyment of the house. So if it is a dwelling house, then the right of preemption comes in, which the other co-owners can exercise and buy off the purchase. Otherwise, in any other property, he only acquires a right of joint possession and he claims a right to partition, enforce a right of partition. In other properties, the law of preemption will not apply. It will only apply in case of dwelling houses. So, this is all that a third party right has. Third party has over when he acquires a property from another co-owner. So that is where he gets a right to seek partition other than a dwelling house. Now, so far as registration mandatory of a partition decree or not, there is a lot of literature on it. Initially, before the amendment of the Stamp Act, a partition deed could be notionally stamped for the purpose of giving effect to. But registration is mandatory. The question, the disputes that arose is legislatures all over the country started treating this partition as a transfer of property and hence stamp as a conveyance. And different states had different amendments. I don't know what is the amendment in the state of Sikkim over here. Different states had introduced different amendments for the purpose of deciding the value of stamp and registration so far as this is concerned, this deed of partition is concerned. But yes, all of them were unanimous on the point that a deed of partition requires registration. And now the Supreme Court has gone on to say that oral partition is not recognized in our country. In fact, at 137.4, that paragraph which I just read from that judgment or that records, that says that if you are to set up partition as a defense to the right of a daughter claiming as a co-parcenary, that right has to be by way of a registered document or a decree of court. So this answers the question that decree of partition, even if it is inter partes, is mandatorily required to be registered. Otherwise, it does not affect any right, or it's recognized by a decree of court. If it is through a decree of court, then there is an authority which says that the decree has to be registered. Because without that, you don't acquire a right to immovable property. So a decree can be registered also for the purpose of cementing your right insofar as the immovable property is concerned. Do we have any other things, any queries as of now?
relinquish your share in a property, what are the circumstances under which that can be utilized?
Madam, if you are relinquishing your right in favor of a co-sharer, then that can be done by executing a deed inter partes. But attempts have been made to perpetrate fraud on the statute or on the revenue by giving a name of relinquishment to a transfer. Suppose relinquishing means I am giving up a known right, it's waiver, the consequence of waiver. I am giving up a known right to property. If you are doing it in favor of your own brother or sister who is already a co-owner of the property, there is no effective transfer taking place. You are just giving your right so that your brothers or sisters share in whose favor, or the co-owners share in whose favor you are relinquishing, his share in the property increases. There is no effective transfer. So that is relinquishment in the true sense of the term. That document need not necessarily be stamped and registered as a transfer. It can be done by a nominal transfer fee under the different schedule of the Stamp Act. But to defeat the purpose of to defeat the legislation or to commit fraud on the revenue, what nowadays people do is they bring in a third party inside the joint family so as to and relinquish a right in his favor. In effect, a transfer is taking place without paying the requisite stamp duty to the exchequer. Now, this, if questioned in a court of law, there are authorities, if you want I can pass it on to you, which will recognize that by requisition a third party cannot acquire a right. A relinquishment has to be within. So if you want to relinquish your right in favor of an outsider, which that tantamount to transfer. Anything more you want to know on the relinquishment, or did I get your question right?
Like, are there any specific things? Because it could be fraud also, it could be under duress also. So
Yes.
What does the court look into?
If you are compelling somebody to relinquish a right by fraud, by coercion, or by undue influence, then the person who is complaining on whom the fraud or undue influence has been committed, he can come and file a suit for setting aside of the relinquishment. That can be done under any of the grounds on which a contract can be nullified. That's under section 16, 17, 18 and 19 of the Contract Act. Any contract, because relinquishment is in the nature of a contract itself, which you are relinquishing in favor of somebody. So that can be challenged. And that can also be challenged and be questioned in a partition suit also.
Can it be challenged by the heirs of the person?
Yes. The burden of proof will be on them to show that my mother or father was coerced, or she or he was in such a situation that she did not do it voluntarily, or was under the influence of the other people, or were compelled to do it, or he or she was fraudulently induced to sign something which she did not intend to. Yes, this can be done. This can definitely be done. And so far as fraud is concerned, or these situations are concerned, more often than not you will find that the question of limitation comes in. As to since when you are aware of this. Because when a legal heir comes and challenges it, the first question is, the person on whom fraud was perpetrated during his or her lifetime, they did not come forward to challenge. So the burden shifts on if the legal heir is coming, then he will have to share, he will have to discharge not only the burden of proving fraud or whatever undue influence, he will also have to discharge the onus of how long and when did he have knowledge of this fraud. And more often than not in these cases you will find that the courts have held that if the person on whom the fraud has been perpetrated did not challenge it during his lifetime, then as a legal heir you don't get a right. That's number one. But there are cases where you will find that the person on whom the fraud has been perpetrated was illiterate. So during the lifetime he may not have realized that a fraud has been perpetrated, the legal heir may get arrested. So that is why in cases of fraud and undue influence or cases of this nature, the Limitation Act says from the date of knowledge. So that saves the limitation. Anything else?
So there's actually Sikkim is a border state between Nepal and Bhutan. So we have a lot of people from Sikkim, especially girls married to Nepal. So
You have a lot of cases from Sikkim?
So there are a lot of situations where women from Sikkim marry Nepalese citizens, and then they come back later because the marriage didn't work or something, and then they seek their co-partner rights. So in general, if a woman in India gets married to somebody who is outside and also takes citizenship of that country, but then later because of personal reasons come back to India and claims a citizenship and co-partner rights. So what are the scenarios? What would be the...
Well, this problem was sought to be addressed probably in that Sikkim Succession Act of 2008. There is a provision there, though it has not been notified. I think there is, I have read that, there is a provision which says that if you are not a CFI, that's the term they use, CFI.
So I'm not just talking about Sikkim, but I'm talking about in general in India.
In general, as I told you, in general in India, marriage doesn't take away the status of a co-partner. That was what the 2005 amendment is all about. You are a co-partner by birth. So whether you are married, not married, makes no difference to your co-partner rights.
So then when you acquire foreign citizenship, then the question of your right to registration of the property and all of that comes.
Yes,
Because when you acquire citizenship of another country,
by virtue of marriage,
by
yes.
virtue of marriage, or even
You can shift abroad, you can adopt the citizenship.
So how does that property then be registered in India if you come back?
You have to take the permission of the Reserve Bank of India. You will have to pay the appropriate fees, but it's not that citizens of other country don't hold property in India. They all hold properties. If it is ancestral property and thereafter they have moved out, so their ownership is there. They can also acquire property, but for that acquiring the property or acquiring assets in another country, you will have to take permission. If it's India, it's the Reserve Bank of India. And the authorities are given, they will have to pay the same registration fees. Because under the Registration Act and the Stamp Act, there is no discrimination between foreigners and citizens. There is no difference. But property can be held all over the world today, all over the world I can hold property. It's only depending on the country in which you have to abide by the laws. So far as India is concerned, foreigners can hold property in India and they have to comply with the guidelines of the Reserve Bank of India for acquiring properties in India. Anything else? Because I think that's the end of the topic that we have today. In these sessions, it would be better if we can have specific problems. Generalized, because there is no point in discussing general law with gentlemen like you. You are doing it every day. That's your business. So if there are specific problems, then we can do that research. Like when I came to Sikkim, then and only I came to know that there is a problem regarding the application of Hindu Succession Act. So what I can do is I can go back and do my research, talk to some of the judges in the High Court, and can send you a paper as to how things can be done. Because this is a problem which I think needs to be sorted out. Or any one of the cases goes to the apex court and the apex court takes a call on what is the law, decides its once and for all. To the end of whatever was today's itinerary, only thing is that the problem which we were discussing regarding application of Hindu Succession Act, I think I'll take up this topic with the Chief Justice and see what can be done, because this is a problem.